But now it is totally different. Now you come in industry, the legal field, industry from day one, there are some junior advocates, they really perform well. And I am their understanding of the law and their augmentative skill. It's really because of the infrastructure that obtained for the over period of time, and the quality of teachers, legal awareness. It is made available to law students. Now, this first lecture, when Mr. My learned senior advocate asked me that I should come and speak something on criminal law, I said, I was pleasantly surprised first, but I said, I didn't know why me. I didn't ask you why me, because there are several leading advocates and renowned judges who served quite well in criminal side. I joined as a civil judge, come judicial magistrate, and over the period of time learned the criminal law bit, and then ultimately I became a High Court judge, retired in May 2024. Thereafter, I joined as a chairperson of Debt Recovery Appellate Tribunal. It's totally different domain, different area. I completely lost touch with the criminal law. He said, no issue, judge, you please come and share your experience. So I prepared a bit. I'm not going to have this as a lecture kind of a session. I want to share my experience with you, and I think it is better that we have it as interactive session. Okay, I'll just give an overview of the criminal legal subjects available for you to explore and choose your choice to master it and indulge in practice. We start with, as I said, this I demoted my office as a judge of High Court in May 2024. So then what happened, this all this primary criminal law, that is Indian Penal Code and primary procedure code, criminal procedure code, and of course Indian Evidence Act, there are lot of what changes have been made. Of course, many of the important provisions are retained. A lot of changes have been made, and in Indian Penal Code is now known as Bharatiya Nyaya Sanhita, and Criminal Procedure Code is now known as Bharatiya Nagarik Suraksha Sanhita, and Indian Evidence Act is now known as Bharatiya Sakshya Adhinayam. So it came into effect only from 1st July 2024. As I said, there are some key changes made, but most of the provisions are retained, except the order is changed, section numbers are changed. So what is now introduced is some with technology and to suit modern societal needs, certain provisions are added. Then it introduces electronic filing, then trial by video conferencing, and there is time fixed for disposal of a criminal case. Of course, certain offences newly defined and fixed penalties are imposed. Terrorism is defined with fixed penalties for organized crime and mob lynching. Then, of course, CRPC, now known as BNSS, exempts women and children and seniors from visiting police station and connected with station visit. And also, community service is introduced as a new form. There is also an important provision, which is because in criminal cases, many cases are pending. Why? Because accused, they don't appear. After getting bail and after attending hearing for some time, they go absconding. It is difficult to trace them. And That is a primary. If you take, the pendency details, we used to have pediatrical review of pendency of cases. Chunk of the cases, at least 50% of the cases are pending for want of execution of NBWs or want of summons. So now there is a provision made available in the new BNSS that in absentia trial can also be conducted subject to following set of provisions. Once the warrant is issued, then proclamation has to be settled for him to appear. If even thereafter, if he doesn't appear, then trial can be held in absentia and judgment can also be delivered. And I think this will greatly help in reducing pendency of criminal cases. Of course, now I said this Indian Penal Code, now known as Bharatiya Nyaya Sanhita, it defines almost every offense, starting from offenses against person and offenses against property, offenses against state. So you name whatever, you can find a definition for that. Now, coming to Indian Evidence Act, it is a mix of substantive and procedural law. It has some provisions which are substantive in nature and some provisions which are procedural in nature. So only these three enactments ruled the rules so far as the criminal justice administration is concerned. There are certain other major criminal enactments which you must know. They are like you say now recent trend where you can reporting in newspaper on day-to-day basis the offense of sexual nature committed against children, POCSO. This is serious offense, of course. Entire the offenses under narcotics and psychotropic substances act is on the increase. Then, of course, there are other criminal laws and of Corruption Act, Money Laundering Act. Both. There are other enactments like Food Safety Act. Earlier, it was known as Food Adulteration Act. Then Mines and Mineral Act. See, on a daily basis, you can come across some reporting in the newspaper. And now I request the organizer to just have the hand mic ready so that the participants may raise their query. I can reply. If I don't know the reply, they're renowned senior advocate, criminal advocates are there. They're here, there, everywhere. So we keep this lively instead of, all through the 5 years, I am informed that it's a mix of students starting from 3rd year, 4th year, and 5th year. Yes, so you learnt what is FIR? What is an FIR? Anybody? Anybody, please? First information report. Anybody? As in simple term, if an offense happens, one goes and gives a complaint to the police. The police registers, it becomes an FIR. Yes, yes. You have a mic, hand mic? Yes, yes. Okay, that is our first information report.
First information
report, yes. What do you mean by first information report? Yes, yes. Yes, yes.
official complaint police.
Okay, fine. That there are two ways of initiating a criminal proceedings. One by giving a complaint to the police, and police, if the complaint gets registered, it becomes a first information report. Then police proceeds with the investigation of the case. There are other way of initiation of criminal proceedings. Can you say, any one of you can say what is the other way of initiation of criminal proceedings? Yes? Okay, I'll tell. Complaint. So that is, we call in a popular language, a private complaint. Private complaint, you can't just go and give a private complaint. If cognizable offense or non-cognizable offense is made out, you have to first approach the police. If the police receives your complaint and registers an FIR, then it is a state which prosecutes the case on behalf of the complainant, the citizen. In some cases, what happens, police may not register the case. The next step is you have to approach the concerned SP of a particular district with a complaint to register the case. Even if this does not happen, then you can approach the concerned jurisdictional magistrate where the offence had taken place, dropping a complaint and filing in the concerned court. The magistrate goes to the complaint and he can choose either to record his own statement of the complainant and proceed further. Otherwise, he can refer it to the jurisdictional magistrate under section 156(3) CRPC for registration of the complaint. Even after that does not happen, then again magistrate will regard the sworn statement of the complainant, then witnesses, if any, presented by the complainant, then that complaint will be taken on file and will be given a calendar case number, probably mostly in warrant cases, I suppose. And if the magistrate comes to the conclusion that the complaint allegation and the statement of witnesses do not make out any case for taking cognition, can even dismiss the complaint. It takes a complaint on file, the cognitions of the offences, then summons will be issued to the accused. Otherwise, the complaint gets dropped. Then you, of course, your remedy available before Sessions Court by filing appeal or approaching Hon'ble High Court under jurisdiction Article 226 or whatever. So this is how a criminal proceeding is initiated, either by registration of FIR or a criminal complaint before the concerned jurisdictional magistrate. Then comes, I said, can anyone say what is a cognizable offense and a non-cognizable offense? Can anyone say about that? What is a cognizable offense? What is a non-cognizable offense? You learned, right? CRPC, you studied, so CRPC or BNS is whatever. You learned now? It's better you don't bother what you're saying is right or wrong. This is how we learn. Only by doing mistake we learn. Nobody cannot be right all the time. This is offense. Right? Less serious offense. No, the simple definition is a cognizable offense is offense for which a police officer can arrest without warrant and can initiate investigation without the prior permission of a magistrate. But as you said, It's not less serious offense. It is a serious offenses like murder, robbery, theft, or something like that. A police officer, if he comes to on his own knowledge, or he comes to know that through some complaint, if a cognizable offense is made from the reading of a complaint, it is mandatory on the part of the concerned police officer to register the FIR and proceed with the investigation. The leading case on this subject is Lalita Kumari's case. Okay, they cannot say that we cannot register the FIR. The reverse is in non-cognizable offences. Police officer cannot register the FIR without the prior permission of the magistrate and arrest an accused without the permission of the magistrate. So this is a basic distinction between a cognizable offense and a non-cognizable offense. Similarly, you have what is a bailable offense, what is a non-bailable offense. Yes. How to get a warrant? How to get a warrant? In a sense, see, once normally, if a cognizable offense is, warrant. How to get a warrant means? Warrant is something that given by the court to arrest a particular person. Warrant is something writ from the magistrate court or the sessions court to arrest a particular person for commission of a certain offense. No.
Before the
No. I said, if a cognizable offense is committed, supposing murder takes place. What the police, it is a cognizable offense. The police can register FIR without the permission of the court and can also arrest the offender. For that, warrant is not required. For arresting accused who committed cognizable offense, no warrant is required from the court. So the police officer arrests the accused and proceeds the investigation. Whereas in a non-cognizable offense case, he has to obtain permission from the magistrate, then warrant will be issued by the concerned magistrate. Only the magistrate, judicial magistrate, on cases where, in some cases from the sessions court, accused absconds, then the warrant will be issued by the concerned session judge. So normally, the judicial magistrate would issue the warrant for arrest of an accused. That should be signed only by the magistrate, not by anyone else. Yes?
before FIR file, we can get a warrant or after
No. Before
complete-
FIR, there is no offences reported at all. Before FIR, there is no question of issuing warrant by any magistrate. FIR has to be registered first. It should be a cognizable offence. Then the magistrate would issue. The police officer can arrest. Non-cognizable offence, after getting permission from the magistrate, they get warrant from the court and also go on. So 138 case, you know about 138 cases? Check dishonour cases. It's primarily a private complaint case, someone's case. That is when only the magistrate issues the warrant to the concerned judicial police and they execute the warrant. So this is a basic. Then, of course, do you know the difference between bailable offence and non-bailable offence? Why nobody is answering any, asking any question? Come on, you all read it, no? We're all some of you are 50 year students, and you must be knowing all these basic aspects. Bailable offence, non-bailable offence.
Good morning.
Yes, ma'am.
So bailable offence is not a serious crime or it's like a minor crime, and it is a matter of right of the persons. The police can give the bail or from the court, but non-bailable offence is a serious crime, and it is about the discretion of the court to give the bail or not.
Well, how do you know whether a particular offense is a bailable offense or non-bailable offense?
The offenses like rape, murder, at all bailable.
Okay, that serious offenses, certainly it is not a bailable offense. How do you know whether particular, supposing it is not an offense, I slap you, okay, whether it's a bailable offense or non-bailable offense?
Yeah, it's mentioned the BNS, so it's bailable.
Yes, there is a second schedule to the CRPC or BNSS, whatever. It every offense is listed there. It says what is a bailable offense, what is a non-bailable offense. Okay, so these are unless you know the basic definitions of what is a bailable offense, non-bailable offense, FIR complaint, and cognizable offense, non-cognizable offense. It is required. It is required if at all you want to pursue practice in criminal side. Then of course there are, now we come to stage where offences committed, criminal cases registered either by filing complaint to the police or private complaint. Then there are distinction of cases depending upon the duration of punishment. Summons case, warrant case, sessions case. So summons case, warrant case, sessions case is all defined in the CRPC or BNSS. So what happens, summons case, the procedure is very simple procedure. On the accused appearing before the court, he is asked whether he pleads guilty or not. He says that he doesn't plead guilty, then trial proceeded. Punishments are, of course, as you said, minor offenses, mostly minor offenses. Then warrant cases. Warrant cases, it's in a serious offenses. Offenses which are likely to be punishable with about 3 years, about 2 years, about 2 years. Till 2 years, it is summons case. About 2 years, it is warrant case. Then again, warrant case, you have two different cases. One is, as I said, cases instituted on the police report. Other segment of cases is cases instituted otherwise than on police report. See, these are distinct features. Both have different procedure for starting from framing up charges and till the judgment. Then, of course, we have the serious offences cases like murder, rape, this and that. That is sessions cases. Sessions cases, whether it can be filed directly before sessions court, can anybody answer? Whether a murder case, this, the second schedule also states which offense is triable by which court, whether it's a magistrate court or it is a assistant sessions court or the sessions court. Can a murder case be directly filed before the sessions court? Can anyone answer? Yes? No, that is not the case. See, whatever the case, any case, the first information report reaches only the jurisdictional judicial magistrate. After the final report, popularly known as charge sheet, is filed, all the accused are summoned. Once they appear, magistrate will supply copies to all the accused under Section 207 CRPC, and then he commits the case, sessions case, to the concerned the principal session judge, from where either principal session judge can retain the case in his file or he can transfer to additional sessions judge. So normally serious offences, normally this is the practice, this is what is CRPC mandate, is that only magistrate does this preliminary he registered as preliminary registered case, then everything is accused appears, copy is furnished, then commits. Then trial takes place and the case gets convicted. But of course, there are certain other cases where direct cognizance is permitted by the sessions court, like the cases under ED, filed by the ED, under the Prevention of Money Laundering Act. can be directly instituted before the special court, normally sessions court. So this is the bird's eye view of the structure of criminal courts and basic offences, and then were not interacting at all. Want to know anything from me by experience? Want to ask anything? About any leading landmark criminal laws? Anyone want to become a judicial officer? What is your aspiration? Whether you want to be advocate, for advocate in the sense whether you want to be practicing in the civil side or criminal side, or commercial dispute, or tax law, or a judicial officer, get into banking service, or some corporate law practice, corporate service. What is that your aim?
Sir, I have one question, sir.
Yes, ma'am. Welcome.
Sir, actually, you told that the offences against the children in sexual harassments are the punishments are severe now.
Yes,
after the BNS Act.
Yes.
So
Poxo.
yeah,
Poxo.
Poxo and also to the women also, sir.
Yes, yes. Yes.
So my question is, these strict punishments really these strict punishments will be the solution for the crimes because still these sexual harassments are happening day to day,
Correct.
even though the punishments are stricter and more severe. So what is your perspective about
Yes, madam. The more the severe punishment, it has a deterring effect. But as you said rightly, despite various, earlier we had IPC. It defines what is a rape, what is a molestation, this and that. But still, it was lacking to provide a better protection for the children. Therefore, this act is enacted. But my view is that after this act, after you could notice on daily basis some judgments are delivered under POCSO, serious convictions or grave convictions are imposed on the accused. Certainly, it will have a deterring effect. But despite that, why this offences is on the increase? Certainly, I don't have a question, answer to this, ma'am. It is a societal and a psychological issue. It's a disturbing, in fact. But we have to see. Those days, we had when we studied, we had a moral session, moral classes. Moral classes, everything was taught to us. We were taught what is right, what is not. So we were cautioned not to venture into some illegal activity. But that is totally missing now. No school offers moral lessons. No school even has a better playground for. That is a basic.
At all taken by the maths teachers.
Correct. See, the marks are only focused. It's like a factory creating students with higher mark for them to land in some premier institutions. But that should not be that will no way give you all-round development of a student. Maybe he is academically good, but morally he may be weak. Because that education is lacking in the school or college. we have to, as a conscious society, we have to all find a way about that. But certainly, madam, returns in punishment will result in a reduction of crime rate. That is for sure. You see, if you go to the Arabian countries, that punishment is very severe. The death sentence, packing, and amputation. Well, therefore, they think twice before committing them. Another thing is that the punishment is swift. Once offense is committed, punishment is swift. Here we have, unfortunately, we have a system. We try to improve the system, but still, because of the procedural lacuna and sheer volume of our population, that's one thing. Sheer volume of population. See, we have in some Western countries, they have 50 judges for 1 million population. We have only about 10 to 13 judges per 1 million population. What is the population? The judge and populace ratio is very minimal. Courts are very minimal. And the legal awareness created invites lot of frivolous litigation. That is also a cause. That is also a cause for increasing the vote in a court. So these are all the contributing factors. So the punishment is not happening. So supposing offense is committed, at least in 3 months, judgment is delivered, convicting them, then whoever reads that, whoever comes to know about that, will think twice before committing the offense. That is not happening in India. We have been making constant effort to improve the system. Still, that is the plight today. We are still trying to improve this. Yes, anything else? I have some leading case laws taken out to you for discussion. Yes, ma'am.
I asked the question in Tamil. First, Tamil language.
Yes, ma'am.
வந்து அந்த மாதிரி ரேப்போ அஃபென்ஸோ கமிட் பண்ணிட்டாங்க. பட் ஆஸ் அ அட்வொகேட் இன்னசென்ஸ் லோ இல்லைன்னா அவங்கள அக்விட்டலோ பண்ணிடுவோம் சார். அது எனக்கு தினமும் யோசிச்சுட்டே இருப்பேன். அவங்க தான் மர்டர் பண்ணாங்கன்னு என்கிட்ட வந்து சொல்கிறாங்க. நமக்கும் தெரியும் அவங்க தான் மர்டர் பண்ணாங்கன்னு. நாம் இன்ஜஸ்டிஸ் தானே சார் பண்ணுறோம். அக்விட்டல் நம்ம வாங்கி தந்துடும் ஆஸ் அ வின் த கேஸ். பட் ஆஸ் அ ஹியூமன் இன்மை நம்ம வாங்கிட்டாலும் இன்ஜஸ்டிஸ் தானே விக்டிம் பர்சன். இஃப் ஐ வாஸ் அ விக்டிம் இட் வாஸ் அ இன்ஜஸ்டிஸ் இல்லை சார். யோசிச்சுட்டே இருப்பேன் சார். நான் ஏதோ ஜட்ஜ் கிட்ட தான் கேட்கணும்.
இதுக்கு ஆன்சரே கிடையாது மேடம். ஸோ யூ ஹாவ் அ ப்ரொஃபஷன். இதுக்கு ஆன்சரே கிடையாது. யூ ஹாவ் அ ப்ரொஃபஷனல் டியூட்டி. See, that it is not your duty to get the acquittal of an accused. Your duty is to prove that justice is rendered. Justice is put on hold at the high pedestal. See, why a case gets, we know pretty well, a daylight murder happens. Somebody gets arrested and prosecuted, gets acquitted. Why? There are 3 possibilities. One is there was no proper investigation by the police. Police missed out some important evidence to collect important evidence. So that is one stage. Even if they collect evidence, it should be presented properly before the court by the public prosecutor. He has to examine all the relevant witnesses, then mark all the exhibits, produce material objects, and present his case in the best possible way to ensure that a case gets convicted. If he fails in his duty, despite police collecting volume of materials to sustain their charges, if that is not presented before the court, the judge is helpless. Okay. Other possibility is that good investigation, good presentation of case by the public prosecutor, judge ultimately fails. He fails to notice, he fails to properly appreciate the evidence and then give a wrong judgment means that is also possible. For everything we have check and mechanism. It is not end of a criminal trial. If a person is properly convicted, it is fine. If he is aggrieved, he can file appeal before the High Court if it is a sessions appeal, and magistrate court appeal means to the sessions court. If he is wrongly acquitted, state can file the appeal. So this we have layers of criminal judicial justice delivery system, starting from magistrate court, then sessions court, then High Court, and Supreme Court. Okay, so this is a long litigation, and then why you are defending means you are defending whether he was rightly charged, and if anything, it is not as if every criminal case should be ended in a conviction. Supposing a murder takes place, there are many cases where a murder takes place due to sudden provocation. In a fit of rage, a sudden fight, or one person, he is responsible for inciting that reaction from the other person. Or without premeditation, it happens. Or just push and pull happens, it just pushes that person. Without knowing that he suffers with some serious diseases, he falls and dies means his intention was not to murder him, not to kill him. He just, a sudden fight happens, he just, in the fight, he wants to save himself and just pushes, he falls and dies. It is not definitely, it's a murder. So you have to, as an advocate appearing for the accused, you have to tell the court, even if there is evidence, it is certainly not a murder. It happened all of a sudden in a sudden fight, and he just pushed that. Probably he may or may have some, or there may be some stone. Without knowing there is a stone, he pushed that, he fell, hit on his back, back of the head, dies means. You have to see the intention first. See, there are various layers of murder case. This is culpable homicide amounting to murder, culpable homicide not amounting to murder. See, if it is a culpable homicide amounting to murder, punishable under section 302 IPC. If it is culpable homicide not amounting to murder, 304 part 1, part 2. Even some cases, there are some cases where accused were awarded a minimum punishment under section 324 IPC. Just nothing happened. Just slapped him without knowing that he has some serious. I just punched him without knowing he has some. You all read the definitions in IPC, no? That's all. So see, your job is primarily not to conduct the case with a view to get the acquittal of the accused. Just render justice to the criminal justice system. In the way, you have to look all these aspects, whether rightly charged, whether all the procedures are followed properly, and in case many advocates, I know for sure many advocates, if they know that the offence is proved, they will not argue for acquittal. They will argue for only lesser punishment. One just great example is our renowned senior advocate, Late Adv Rajgopal. See, the advocates many times, I saw them as a magistrate sitting in a criminal trial. They try to get favorable answer from the witnesses by threatening or terrorizing the witnesses. But his way of cross-examination, something we must emulate and follow. Very persuasive. He goes sail along with the witnesses and then gets whatever the answer he decides. And even in the argument, even during the course of argument, is very short, just like Mostantram, he ingrained that qualities from him, very short talking. He never raised his voice in the court, never rubbed the judge on the wrong side. That does not mean that he will just accept whatever the judge says. He says, he convinces the judge his own imitable side. So that is the argumentative skills, presentation skills you all must develop. You must, my sincere advice to you is to join, be it civil side, whatever, join a good advocate's office, be there for sometimes in a trial court, spend some time in trial court, learn the nuances of presenting a case, cross-examination, argument and then switch to High Court or Supreme Court, whatever, your expertise level would be much better than what one directly goes by. Anything else?
One more.
Yes.
In my internship, for a corruption case, vigilance, we file a case. For that case, they are getting corruption, sir.
These are malaise in the society, madam. Malaise in the society.
So what is the use of?
Madam, the corruption is one thing, unless the person who does not want to corrupt the system should be on the increase. See, there were a time once the result is not important. The way you get the result is important in a morally, legally right way. Now that is not the position, right? See, everyone wants to win the whatever, win their whatever venture they into. They are ready to corrupt. They don't want to wait in queue. Supposing you apply for a house building plan, okay, you wait till when it is approved, it is fine. You don't go to the office and don't corrupt them. It will come one day. But what happens? See, you want to get the building plan approved immediately. So you go and offer some bribe. Earlier they took bribe, only it was offered. Now it turned to the worst that it is in practice. Unless you give a bribe, it is not possible. Unless the public make a conscious decision that we will not corrupt anyone for things to get done, this will never get eliminated, maybe curtailed, controlled. Corruption is not a new concept. It has been there from in the evolution of human. Okay, this morality is on the wane, getting reduced. Therefore, corruption is on the increase. See, law can only control things. Prevention is totally not possible. Can only control the corruption.
Thank you, sir.
Yes, sir. Yes, I have certain decisions leading case laws. In Josephine versus Union of India, it's a leading case on adultery. Anyone knows about that? Okay. So that was a case, section 497 adultery, that punishes only the man and treated the women as a property of the husband. So that was challenged as violating equality, dignity and personal liberty. Supreme Court held that this adultery is only a private civil wrong and not a crime. And therefore, consensual sex cannot be punished, and that provision was held arbitrary and violative of Article 14 and 21. So, do you know the procedure of arrest by the police? There are certain lead case laws on how to arrest the accused and what are the procedures to be followed by the police in arresting the accused. I told you about Lalita Kumari's case with regard to registration of FIR in cognizable offences cases. Right? And then a leading case, DK Basu's case. Have you heard of DK Basu's case? What are the procedural formalities to be followed by the police before arresting the accused? like arrest to happen within 24 hours of the production of accused before the jurisdictional magistrate within 24 hours of arrest, and that intimation should be served to the relatives of the accused on arrest happening. Then there's eternal judgment on Arnesh's case as to how the arrest happened. Any idea? Maybe it is too tall for me to expect you to know this. Yes, anything else? The made certain pertinent queries. I share my experience. Anybody? I share one in a murder case that I dealt while I was serving as additional session judge in Salem. That was a case in a family 6 murder took place. A father, his wife, his son, son's wife, and 2 of his kids were all murdered just for property dispute in connection with 5 acres. You want to know about that? See, actually, they are not distant. They are blood of a same family. Father was a retired inspector of police. He lives with his wife, his second son's wife, and their 2 kids in a farm. First son, his wife and son got separated. He gave a chunk of his property to first son and his family, and they live elsewhere. This is a farm. He intended to keep it for himself, his wife, and his second son and his family. But the first son, what happened? He eyed for this property. He joined with a powerful person, enters into some kind of a sale agreement, this and that, and asked the father, give me share in this property. Father told him, no, already I gave you whatever the share you wanted. This is, I keep it for myself till my life, and thereafter to my second son and his family. So I will not give it. Tried by several means. Ultimately, father and his brother, they not succumb to this pressure. So what happened one fatal day? That was fatal day. On that day, some festival happens in the city of Salem. Festival happens throughout the night. Second son, his wife, and 2 children. I've been to that festival, and during midnight, about 2 or 3 p.m. to 3 a.m., they come back. Motorcycle. And to festival, the motorcycle. On reaching the home, they found their elder brother and his son standing. They wondered why they were standing, but without any warning, they threw chili powder on their eyes and just cut them with the axe. All the four died. This offense had happened in a particular day, particular night. There was not known to anyone, at least for 36 hours. Thereafter, the accused, knowing that somehow police will know the offense, commission of offense, and get to arrest them, they go to a different district and approach an advocate for getting anticipate bail. The case where no FIR is at all registered. Only then police come to know, only from the advocate who was who filed application for pre-arrest, police come to know such an offense had taken place. Then police visits that house. Horrific scene. Parents murdered inside, all full of blood. The brother, his wife, and two children murdered outside, dragged into inside, locked. House was locked outside, till left. Thereafter, FIR was registered and investigation conducted. They were arrested. The father, son, duo, both in actual commission of murder, they were arrested, along with certain other abettors and conspirators. So this came to me as a first additional assistant judge. I was about to frame charge on a particular day. Why the murder trial gets prolonged is that we schedule a particular date for framing charge. One or some of the accused will not come. Then it has to be urgent. Something like that was going on. Then one fine day I said, if you don't appear, I will take steps to cancel the bail and then I'll frame charge. Then next day they come up with a discharge petition for one of the accused. Did not stop with that. I supposed I started hearing a matter where I was about to pronounce order, another discharge petition for another accused. You see the melody of the criminal justice system we have now. This is what is happening. So just like that, 5 or 6 accused file discharge petition, my brain worked. I did not pass orders in the discharge petition. I just kept the matters pending, and ultimately I decided the discharge petition and dismissed all the discharge petition. Thereafter, one of the accused filed some revision before Hon'ble High Court. I am informed that it was allowed. So I don't know what happened thereafter. So I left the scene. Why I am sharing this view is that, see, the offences take place primarily for 3 reasons. The mannu, ponnu, apro, tangam, whatever desire, undesirable desire. That is the reason primarily for offences taking place. Then, of course, with the present legal system, we are not able to secure, despite the best efforts made by the government and the courts, immediate justice is not possible. These are all contributing factors for the increase of offences. You are the future of legal profession. And my earnest desire to request you to study well, whatever the field you take, be it the civil side or commercial side, read. Unless, as I said to start with, it may appear that overcrowding in legal profession to start with, prima facie it may appear, but reality is that the advocates who are proficient in the field they take, are very minimum. Only those advocates who succeed in the profession of advocate and succeed in becoming judicial officers either as a judicial magistrate or as a district judge by direct recruitment or directly elevated to Supreme by High Court. There are advocates. Advocates, I mean, they are directly elevated to Supreme Court as well. For instance, Justice K. Visurathan, the judge of Supreme Court, all along been advocate and he was elevated as a judge of Hon'ble Supreme Court of India. So read, unless determined reading is there, not only read, you should read with understanding. Not only you should understand, you should try to analyze it with corresponding laws and connected laws, and should appreciate that. How do you appreciate? You have to read journals. So, if you go to Google search, you can type a particular law point, you can get plenty number of decisions. See, law to understand, to read, we may think, we may import a meaning, but courts to law of interpretation interprets the law in a different way. So we must understand what law say only by the interpretations of the higher court, like High Court and Supreme Court. But to not only stop with reading text, but that is textual reading is very, very important. Unless you know the first principles of law, unless you know what is an offense as defined in a criminal law or a civil law, with its illustrations, understands it, appreciates it, then applies it. It is you all will be 1 in 1,000. But you must become a face in the crowd. To become a face in the crowd, you must set apart from others. We get a notice. Once a junior comes, who is performing a mediocre role, who is performing outstanding. The outstanding advocates, especially junior advocates, they come thoroughly prepared. They are thoroughly prepared. They are ready to answer any questions posed by the tribunal for clarification. So that set of proficiency you must have. So if you don't have any further questions, shall I conclude? Yes, ma'am.
Decided. So we go again to the police station, but still police says the order is not mentioned. It is not mentioned to me, though it is decisive. So you have to get a new order from the court for me. Still, they have this section 329 of PNS for criminal trespass. Still, they refuse to do their duty. So whether it is attracted by section 198 and 199 of PNS, their action is.
I don't want to get into technicalities, factual of the case. See, you filed order, you got order from High Court?
Yes, sir, it's a division bench order.
See, in that case, the next course open to you is you can file a contempt petition before the concerned bench for initiating action against contempt action against the officer who is a respondent who refused to register. Then division bench directs registration FIR means it's a criminal offense. Criminal offense is made out. Okay, that is the only option, one option available to you. See, normally what happens, see, the civil litigation gets longer than criminal
So that's
litigation.
why the litigants get exhausted
Okay,
even in these.
civil litigation gets longer than the criminal litigation. So there is a tendency on the part of the litigants to criminalize a civil offense. That happens quite a number of times. just a civil dispute, they give a color of by only drafting, you know. A clever lawyer can draft, even the civil offense, he can make it appear a criminal offense. Okay. See, at the stage of initial cognizance taken, we have to only look at the contents of the complaint and find out whether any cognizable offense is made out or not. Okay. Only during investigation that is right or wrong will come up. Okay. Therefore, the courts are very cautious about entertaining every complaint which criminalizes a civil act. Okay. Okay. I think no more question. I profoundly thank the senior advocate Mr. R. Shanmugasundaram and Maruraj Shanmugasundaram for giving this privileged opportunity for me to address in the first ever criminal law memorial initiated in the name of Doyen of Criminal Bar, Rajagopal. Thank you very much for this opportunity. Thank you.
Thank you, Lordship, for that insightful and thought-provoking lecture. We are truly grateful for your time and wisdom. As we draw the curtains on this momentous occasion, it is fitting that we express our gratitude to those who have made this event possible. To deliver the oath of thanks, we have a distinguished advocate who has been instrumental in the meticulous planning and execution of this event. I now invite Advocate Maruraj Shanmugasundaram to deliver the oath of thanks.
Thank you, Bhavna. It's my pleasure to deliver the vote of thanks today. See, as many of you know or must realize at least now, oratory, which is how you speak, how you communicate, how you present your ideas, is essential to the field of litigation. Or even if you are not in the field of litigation, if you're going to be an advocate, now that you all are started studying law, I'm sure people, when you go back home or when you go somewhere, they will come and ask you for a piece of advice. Sir, I have this problem at home. Sir, we have this dispute in the family. Madam, can you help us with how to sort out this issue with the tenant? So it's very important to understand how you communicate ideas. The whole point of our endowment is to ensure that we have people like the Hon'ble Justice G Chandrasekaran come and talk to you about, firstly, how to present ideas, but our small interest in that is to ensure that you understand what criminal law is and how it is related to society. Our endowment endeavors to provide exposure to leading minds, and Justice G Chandrasekaran, who stands atop our judicial institution, first as district judge, then as a judge of the High Court, and today as the chairperson of the Debt Recovery Appellate Tribunal. We thank him for his time and for sharing his impeccable temperament and for taking us through, very patiently taking us through his journey to the peaks of the profession. Dr. Ranjit said, once a judge, always a judge. But actually, no, today, Justice G Chandrasekaran has been the exception to that. Once a judge, but he can also be a very, very effective teacher. He has taken, according to me, he started by saying he did not know why he was invited to speak today, but I think now we have the answer to, which is so obvious. He has essentially condensed around 12 months of what we give in our offices as, practical training to juniors into 1 hour. So for that, we are very grateful, sir. Thank you so much. On behalf of the endowment, I also want to thank Dr. Ranjit. He has been a steadfast guidance and with his enthusiastic support and warmth, and without such academic leaders who go beyond the call of duty, it is difficult to organize even small events such as this. So, sir, we are deeply thankful to you as well. I want to quickly acknowledge 3-4 people who have come here today. These are members of our own fraternity. Firstly, Mr. Arun Natrachan, Special Government Pleader. Mr. I'll just go through the names quickly, so please, if you don't mind, stand. Mr. Poti Raj, Advocate and Secretary of the Madras Bar Association. Mr. V.T. Balaji, Treasurer of the Madras Bar Association. Mr. D. Raja, Librarian of the Madras Bar Association. Mr. P. Chandrasekaran, Advocate. Mr. S.T. Raja, Advocate. Mr. L. Bhaskaran, Government Advocate, Criminal Side. Mr. A. Gopinath, Government Advocate, Criminal Side. Mr. Aranganayagi, Additional Government Pleader. Finally, I really want to sincerely thank the students. I know it's not easy to come on Saturday, and that too, this is not just any Saturday, it's a Saturday of a long weekend. Monday is Republic Day, but let me take this opportunity to also say that, this is the 76th year since we adopted the Constitution. So, as lawyers, whether you like it or not, whether we defend clients or not, we have to defend our Constitution. So, thank you all and happy Republic Day.
Thank you, sir, for those kind words. May I request now all of you to stand for the national anthem.
Bharat Bhagat Sindhu Gujarat Maratha Dravid Uttar Bangla Yamuna Ganga Ujjala Jalati Shubha Name Jahe Tab Shubhashish Mahe Gahe Dab Jaya जनगण मंगलदायक जय हे भारत भाग्य जय हे जय हे जय हे जय 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 हे.
Thank you, everyone. Please be seated. This brings us to the conclusion of today's program. Thank you once again to the dignitaries, honored guests, faculty members, advocates, dear students and friends. We wish you all a pleasant day ahead. Thank you.